I'll call a case of State of Wisconsin versus Anissa Weier. Same appearances as previously noted. I note the jury is back in the jury box, prepared to proceed. So good morning to everybody. We'll begin with the jury instructions. Then the attorneys will make their closing arguments to the jury. After the closing arguments, we'll select the alternates. Members of the jury, the court will now instruct you upon the principles of law which you are to follow in considering the evidence and in reaching your verdict. It is your duty to follow all of these instructions, regardless of any opinion you may have about what the law is or ought to be. You must base your verdict on the law I give you in these instructions. Apply that law to the facts in the case which have been properly proved by the evidence. Consider only evidence received during this trial and the law is given to you by these instructions. And from these alone, guided by your soundest reason and best judgment, reach your verdict. Evidence is first the sworn testimony of witnesses, both on direct and cross-examination, regardless of who called the witness. Second, the exhibits the court has received, whether or not an exhibit goes to the jury room. Third, any facts to which the lawyers have agreed or stipulated, or which the court has directed you to find. Anything you may have seen or heard outside the courtroom is not evidence. You are to decide the case solely on the evidence offered and received at trial. Disregard entirely any question that the court did not allow to be answered. Do not guess at what the witness's answer might have been. If the question itself suggested certain information might be true, ignore the suggestion and do not consider it as evidence. Lawyers for each side have the right and duty to object to what they consider are improper questions asked of witnesses and to the admission of other evidence which they believe is not properly admissible. You should not draw any conclusion from the fact that an objection was made. By allowing testimony or other evidence to be received over the objection of counsel, the court is not indicating any opinion about the evidence. You jurors are the judges of the credibility of the witnesses and the weight of the evidence. An exhibit becomes evidence only when received by the court. An exhibit marked for identification and not received is not evidence. An exhibit received is evidence whether or not it goes to the jury room. Remarks of the attorneys are not evidence. If the remarks suggested certain facts not in evidence, disregard the suggestion. Recordings are proper evidence, and you may consider them just as any other evidence. Some parts may be hard to understand. You may consider the actions of a person, facial expressions, and lip movements that you can observe on recordings to help you to determine what actually was said and who said it. Draw your own conclusions from the evidence and decide upon your verdict according to the evidence under the instructions given you by the court. The weight of evidence does not depend on the number of witnesses on each side. You may find that the testimony of one witness is entitled to greater weight than that of another witness or of several other witnesses. In weighing the evidence, you may take into account matters of your common knowledge and your observations and experience in the affairs of life. It is the duty of the jury to scrutinize and to weigh the testimony of witnesses and to determine the effect of the evidence as a whole. You are the sole judges of the credibility, that is, the believability of the witnesses and of the weight to be given to their testimony. In determining the credibility of each witness and the weight you give to the testimony of each witness, consider these factors. Whether the witness has an interest or lack of interest in the result of the trial, the witness's conduct, appearance, and demeanor on the witness stand. The clearness or lack of clearness of the witness's recollections, the opportunity the witness had for observing and for knowing the matters the witness testified about, the reasonableness of the witness's testimony, the apparent intelligence of the witness, bias or prejudice, if any, has been shown, possible motives for falsifying testimony, all other facts and circumstances during the trial which tend either to support or to discredit the testimony. Then give to the testimony of each witness the weight you believe it should receive. There's no magic way for you to evaluate the testimony. Instead, you should use your common sense and experience. In everyday life, you determine for yourselves the reliability of things people say to you. You should do the same thing here. You have just heard testimony about the defendant's mental condition at the time of the offense. You will now be asked to determine whether the defendant is not criminally responsible by reason of mental disease or defect. This issue will be presented to you in the form of two questions. One, at the time the crime was committed, did the defendant, Anissa Weier, have a mental disease or defect? Two, as a result of the mental disease or defect, did the defendant, Anissa Weier, lack substantial capacity either to appreciate the wrongfulness of the conduct or to conform that conduct to the requirements of law? You will be asked to answer the second question only if you answer the first question yes. Before you may answer a question yes, the defendant must satisfy you to a reasonable certainty by the greater weight of the credible evidence. The answer to the question should be yes. Evidence has greater weight when it has more convincing power than the evidence opposed to it. Credible evidence is evidence which, in the light of reason and common sense, is worthy of belief. Reasonable certainty means that you are persuaded based upon a rational consideration of the evidence. Absolute certainty is not required, but a guess is not enough to meet the burden of proof. The first question is, at the time the crime was committed, did the defendant have a mental disease or defect? Mental disease or defect is an abnormal condition of the mind which substantially affects mental or emotional processes. The term mental disease or defect identifies a legal standard that may not exactly match the medical terms used by mental health professionals. You are not bound by medical labels, definitions, or conclusions as to what is or is not a mental disease or defect to which the witnesses may have referred. You should not find that a person is suffering from a mental disease or defect merely because the person committed a criminal act, or because of the unnaturalness or the enormity of the act, or because a motive for the act may be lacking. Temporary passion or frenzy prompted by revenge, hatred, jealousy, envy, or the like does not constitute a mental disease or defect. An abnormality manifested only by repeated criminal or otherwise antisocial conduct does not constitute a mental disease or defect. A voluntarily induced state of intoxication by drugs or alcohol, or both, does not constitute a mental disease or defect. A temporary mental state which is brought into existence by the voluntary taking of drugs or alcohol does not constitute a mental disease or defect. Chronic use of drugs or alcohol may produce a condition that can constitute a mental disease or defect if the condition has become permanent. If you answer the first question yes, you must go on to answer the second question. If you answer the first question no, you should not consider the second question. The second question is, as a result of a mental disease or defect, did the defendant lack substantial capacity either to appreciate the wrongfulness of the conduct or to conform that conduct to the requirements of law? If you answer both of these questions yes, the defendant will be found to be not criminally responsible for the offense. And in lieu of a criminal sentence or probation, the defendant will be committed to the Department of Health Services and will be placed in an appropriate institution unless the court determines that the defendant would not pose a danger to herself or others if released under conditions ordered by the court. In deciding whether the defendant is criminally responsible, you are to consider only the issue of the defendant's mental condition at the time the offense was committed. Ordinarily, a witness may testify only about facts Then, however, a witness with expertise in a particular field may give an opinion in that field. In determining the weight to give to this opinion, you should consider the qualifications and credibility of the expert, the facts upon which the opinion is based, and the reasons given for the opinion. Opinion evidence was received to help you reach a conclusion. However, you are not bound by any expert's opinion. The following verdict with 2 questions will be submitted to you. I'm going to have Ken distribute to you a copy of the verdict form so that you'll understand what the nature of the verdict is, and you can retain those during the argument. The following verdict with 2 questions will be submitted to you for your consideration concerning the defendant, Anissa Weier. First question: at the time the crime was committed, did the defendant, Anissa Weier, have a mental disease or defect? If you answer yes to question 1, then answer second question: as a result of the mental disease or defect, did the defendant, Anissa Weier, lack substantial capacity either to appreciate the wrongfulness of the conduct or to conform that conduct to the requirements of the law? We're now at that stage of closing arguments. Consider carefully the closing arguments of the attorneys, but their arguments and conclusions and opinions are not evidence. We'll now begin the closing arguments.